Today, I want to talk to you about the Franklin Armory Title I and the lawsuits and the bills surrounding it. Let's get into that today. But before we do, I want to say thank you to the sponsor of this video. It's me. Yeah, I got a Patreon. I got social media accounts, Instagram, Twitter. Follow me there if you like what I'm doing. If not, that's fine also. If you want to stick around for this video, we're talking about the Title I, so let's get into that. So for those of you that don't know what a Title I or an other firearm in the state of California is, this is a firearm that is semi-auto, center fire, it's got detachable magazines, it's not a rifle, not a pistol, not a shotgun. This is a wrist stabilizing brace. It is not designed to be fired with one hand. It's got a barrel length over 16 inches, but if all that confuses you and you don't know what the heck I'm talking about, I have a video talking about what makes other firearms legal in the state of California, so feel free to go check that out. The problem is that AB 88 was a budget trailer bill in the state of California that was intended to make these considered assault weapons. It was meant to go into effect July 1st of this year. Unfortunately for them and fortunately for us, it was not able to be passed as a budget trailer bill. It's been resurrected now as a policy bill, SB118. What SB118 will do is almost exactly the same as AB 88, which I have a video detailing in full, but to break it down real simple, it moves the date for firearm precursor part background checks, meaning that if you wanted to buy an 80% lower or any other similar unfinished frame or flat, like an AK flat, a Polymer 80 pistol frame, a 80% lower for an AR, you would have to have that sent to a licensed gun store and do a background check on it prior to receiving it. So yeah, that was going to be going into effect in 2025. It's being pushed up to July 1st of 2022. Very unfortunate. Much less time for people to prepare and react to the draconian laws that the state is enforcing on us. It also, in that budget trailer bill, had a section that was going to be defining a firearm that is not a rifle, pistol, or shotgun that has any of the various features or characteristics as an assault weapon, meaning that this gun, which, like I said, is just a normal firearm, it is basically an AR-15 that is not a rifle, not a pistol. This would be illegal under the new law. The problem is they changed the date from July 1st to September 1st, and that does give us a window of opening. I want to read to you a press release from Franklin Armory and then talk about the lawsuits. But basically, you have until September 1st, as the way the law SB 118 is currently written, to place a deposit on one of these to get you on potential standing for two various lawsuits. I want to be very clear. Franklin Armory has their own lawsuit that is suing the state for damages. What this lawsuit is the state has damaged Franklin Armory by not allowing them to sell a firearm that is legal to sell by not updating the DRO system. The DRO system has a drop down for what type of firearm. It says rifle, pistol, or shotgun. This gun is not any of those things, so how can it possibly be sold legally? Well, that's the issue. The DOJ is intentionally not updating their DRO system, so Franklin is suing them for two things. One, so that the state gets their act together and chooses to make the changes that need to be changed so people can go out and easily just buy one of these. And two, it's suing them for damages because they've been unable to conduct lawful business because the state of California won't allow them to do so by not updating a system which very clearly could have been updated in almost the year time, mid-October, I believe, when this was first announced as the Title I being available, but they still can't sell them, and it's August. 10 months later, and they still haven't made that change? I think there's something more to it there. I want to read this letter from Franklin Armory, which I will leave up on the screen for you to read as well. Franklin Armory, let's see. So, Minden, Nevada, July 29th, 2020, mass action lawsuit against the California Department of Justice over its refusal to process legal sales of the Franklin Armory Title I is underway. And now I do want to leave a note that in the hearing for AB 88, the state legislators were very specific to mention that they were going after Franklin Armory and going after their specific company and their product. That's different than a typical assault weapon ban that just generally bans something. This is them going out of their way to ban them and make what they're doing illegal. which some people have brought up the concept of that not necessarily being legal for the legislature to do, to specifically target certain groups of people. But that's a conversation, I guess, for another date, and that I don't personally feel ready to have. So let's read this press release. Franklin Armory goes to great lengths and expense to bring quality products to the market that people want. Franklin Armory has designed, developed, and begun the manufacture of a new firearm, the Title I. That is California compliant, but is neither a rifle, pistol, nor shotgun. Franklin Armory has and will continue lawfully taking pre-orders from buyers in the state. Tens of thousands of Californians have already placed deposits on the Title I firearm so they can get one as soon as they become available. Franklin Armory has made it a priority to deliver on these pre-orders to their customers, but we can't because California Department of Justice is unlawfully refusing to process the requisite paperwork. In response to this inaction, the law firm of Michelle & Associates is preparing a mass action lawsuit to represent those persons who the California Department of Justice has prevented from lawfully acquiring their firearm. If you have made a deposit and are unable to receive your firearm because of the defects in the California DOJ designed and maintained dealer record of entry system, you should consider joining this lawsuit. There are no fees or costs involved for participants. Even though the possession of Title I does not violate California law, the CADOJ has deliberately refused to process sales of Title I. As a result, Franklin Armory retailers cannot transfer Title I firearms to consumers because licensed dealers cannot submit their sales applications to the California Department of Justice online. The state-mandated system, Dealer Record of Sales System, DES, does not allow for the transfer, basically just saying that they're still holding up the process by not updating their system. The sale of Title I firearms are being blocked and the sale of Title I firearms are being blocked by biased CADOJ bureaucrats. The DOJ was made aware last year of the need to add an other category to facilitate Title I sales, but refused to take this step. This technological barrier prevents licensed firearms dealers from proceeding with the sale, transfer, loan, or submission of information to the DOJ. The actual effect is that California firearms dealers cannot accurately submit the necessary information to the CADOJ for processing. This, we believe, constitutes a violation of the CADOJ's duty to accept and process all firearms application and a violation of each purchaser's due process right. On behalf of the tens of thousands of people who put a deposit down to purchase the Title I, the lawsuit seeks to declare CADOJ's conduct unlawful and compel CADOJ and its agents to fulfill its obligations. So they provide a link down below. Basically, here's the deal. If you have not already put a deposit down for one of them, go do so. They will then send you an email with a link and information to get processed with the mass action lawsuit. If you've already got an order placed and have not received an email, please reach out to Franklin Armory to get that information to them so that they can then send you the proper information and get you going. I can't discuss too much about the process of the mass action lawsuit, but I think it's legit. And if you would like to be if you're interested in that, feel free to place an order and get enrolled. Really, we just want everyone to be aware of the two different lawsuits going on. Franklin Armory has theirs, and then there is the Michelle & Associates Franklin Armory Title I lawsuit, which are separate but similar. I really appreciate you sticking through this video. If you have any questions, drop a comment down below. We can have the conversation as much as we can. I don't want to give too much information or talk on things that I'm not prepared for or things that I shouldn't. So we're gonna have to be fairly limited. I just wanted you all to know, check your emails if you've already got an order placed. If you have not placed an order, you still have time to do so, but you gotta do it now before September 1st. You'll get an email from Franklin Armory, at which point you can get in touch with Michelle & Associates and get applied, fill out the information, and go from there. If you have any questions, drop it down below. As always, have fun, be safe, stay dangerous. Peace.